cases with male colleagues, a restriction her superiors claimed was for her own protection. This limitation not only made it difficult for her to do her job, but left her feeling ostracized from her shipmates. Gala began to receive negative performance evaluations and was eventually told by her commander that it would be best for morale if she left the ship. She transferred to a duty station on land, but the retaliation continued when her new chain of command learned about the rape and the ongoing investigation. One member of her new command told her that the rape was only 5 minutes of her life, and she needed to get over it already. In the face of such harassment and ostracism, Gala accepted her superior's offer of immediate separation from the Navy in 2005. Gala and Clay were joined by 10 other plaintiffs, all of whom had suffered sexual harassment or rape. When some of them reported being raped by their colleagues, they were labeled as troublemakers, a label that eventually got them discharged or forced them to resign from the military. Some of the survivors were directed to be silent and refrain from telling anyone about the rapes and the subsequent mistreatment. All of the plaintiffs were on active duty when they suffered these sexual assaults and retaliatory actions at the hands of other service members. Further, most of the sexual assaults detailed in the plaintiff's complaint took place on military bases, military ships, or during foreign deployment. The rest occurred at private residences that were located off base or in connection with social events with other service members. Although the survivors faced immediate and lifelong consequences from their assaults, the rapists suffered few repercussions. The vast majority, the women's complaint noted, were not prosecuted or punished in any meaningful way. Those who felt any consequences at all were permitted by their superiors to receive non-judicial punishment and to be honorably discharged. In 2012, Clay, Gala, and the other plaintiffs filed suit in federal district court against 9 defendants, the 3 most recent secretaries of defense, secretaries of the Navy, and commandants of the Marine Corps. They alleged that the defendants were responsible for what they suffered and for the violations of their constitutional rights. The complaint explained that the defendants were fully aware of the prevalence of sexual misconduct and retaliation in the Navy and Marine Corps and had the power to eliminate it, yet they had taken no effective steps to do so. But the United States Court of Appeals for the District of Columbia Circuit ordered the plaintiff's suit dismissed, saying that military officials cannot be sued in federal court for constitutional violations. The court declared, "Their appeal is both difficult and easy. Difficult because it involves shocking allegations that members of this nation's armed forces who put themselves at risk to protect our liberties were abused in such a vile and callous manner. Easy because plaintiffs seek relief under a legal theory that is patently deficient." The court did not question the plaintiffs' allegations or their assertions that the defendants, top government officials, were ultimately responsible for what occurred. But it held that the federal courts cannot provide relief to those who have suffered violations of even their most basic rights while in military service. It concluded, "In affirming the district court's dismissal, we do not take lightly the severity of plaintiffs' suffering or the harm done by sexual assault and retaliation in our military. But the existence of grievous wrongs does not free the judiciary to authorize any and all suits that might seem just." The Court of Appeals accepted, as it had to at that stage of the litigation, that the women had been raped, sexually harassed, and retaliated against. But the women had absolutely no remedy. They could not sue the United States because it has sovereign immunity. That is, the United States government is completely immune from being sued unless there is a federal statute authorizing it. No such statute existed here.